Good afternoon, everyone. My name is Barbara Lebrun, and I'm very excited to join you now. Although I'm very sorry I've not been able to attend earlier today. I am a colleague from this university, and I've written a book called Protest Music in France, and I teach aspects of French popular music, including its interaction with politics and legislation in the French context here in this university. So I'm very interested in the topics that you've debated today. The title of this panel is Policing and Prosecuting Rap Culture. And we've got two speakers. They will each speak one after the other, and we'll take some questions at the end. So to my right, I've got Karen May, who's come from London and is a solicitor in civil law. And she will talk about a recent case that involves a British client. And to my left is Professor John Street from politics at the University of Anglia. And he will speak about his new research project. So Karen, after you.
Thanks, Barbara. In one sense, I'm on very familiar ground here because I'm back at the university where I did my law degree many years ago, so that's fantastic. Thank you for inviting me. The not familiar ground is obviously the rap music. I mainly do judicial reviews, challenges against public bodies, a lot of education law, community care law. There have been a great deal of changes to legal aid, which obviously has a massive impact upon the population that we serve in North London. One of these changes led to a very interesting case coming my way in 2013. Because I've got a public law franchise, it means I can take any kind of public law challenge. And this case came to me slightly unusual from my normal work, but very, very interesting. It was under Section 34 of the Policing and Crime Act 2009, so it's a civil matter, and what the police and the local authority can do under this legislation is to prevent gang-related violence. That's the focus of the legislation. And what Section 34 of that Act says is that a court may grant an injunction if two conditions are met. And they've got to prove this on a balance of probabilities at this point. The first condition is that the court is satisfied on a balance of probabilities that the respondent has engaged in or has encouraged or assisted gang-related violence. And then the second condition is that the court thinks it is necessary to grant the injunction for either or both of the following purposes: to prevent the respondent from engaging in or encouraging or assisting gang-related violence. And the second one is to protect the respondent from gang-related violence. And then there's quite a lot of detail about what the injunction can do. There's also a definition of what gang-related violence is, which is violence or a threat of violence which occurs in the course of or is otherwise related to the activities of a group that consists of at least 3 people, uses a name, emblem or colour, or has any other characteristic that enables its members to be identified by others as a group, and is associated with a particular area. And that was the allegation in my case, that these young men, they had a particular colour for their gang, and there was a particular area that they covered. Section 35 of the Act allows the injunction to prohibit them from being in a particular place, being with particular persons in a particular place. There's also being in charge of a particular species of animal. I mean, I think we see the association with gangs and particular dogs, and that wasn't an issue in my case, but that is one prohibition that the injunction can deal with. Wearing particular colours or articles of colours in a particular place, and most significantly for today's course and the issue of music, the injunction can prohibit the defendant from using the internet to facilitate or encourage violence. There is some recognition in the Act, in Section 35, that there needs to be avoidance with any conflict with the respondent's religious beliefs and with interference with work or attending education. And Section 36 reminds authorities that the injunction should not go beyond 2 years, and also contains provision for review hearings and also a power of arrest to the injunction, and that's where really my work came in. And it's either the police or the local authority that can apply for the injunction. In my case, it was the local authority, but I have to say, when I pushed to find out exactly what was going on, it was very much the police that were driving the case. My instructions came from 3 members of the same family, and they had this injunction. It was extremely onerous, and the big problem for me was I was being instructed in 2013. In 2012, the injunction had been made. So I was acting under legal aid to try and resist the local authority's application to commit these defendants to prison for breaching the injunction. But I was hampered because the injunction had already been made. So whilst I saw this injunction and it raised a lot of concerns, I couldn't challenge those because those had already happened. It would have really been for those at the time to deal with those matters. The injunction we faced ran to 4 pages of text, plus there were maps showing exclusion zones. It limited my clients in where they moved in the area, prevented them from being in a group of 3 or more people, and they were also prevented from being in the company of 22 specific named individuals. I mean, what concerned me from a human rights point of view is that these 22 individuals were not actually parties to this injunction. I thought, well, I wonder, could any of us be named in someone else's injunction under this legislation and perhaps not even be aware of it? Some of the individuals were family members, and I mean, off the rap music a bit, but one of the young men actually was before the court in relation to having a discussion with his nephew over the garden fence because his nephew was one of the people named in the injunction. Turning to rap music, and the reason we're here today, what the injunction said about the music was that the defendant be forbidden, whether by himself or by instructing or encouraging any other person, from appearing in, featuring in, participating in, making or distributing, including but not limited to retweeting or uploading or putting on the internet, any video, vocal or audio material, visual or written material or image, which contains, and this is linking back to the original legislation I referred to, any threatening, abusive or insulting material, anything which supports or incites gang-related violence, or any reference to a gang or any gang affiliation. And they even then listed in the injunction 8 particular names and phrases associated with the particular gang we were talking about. And they made it clear that this covered any material adapted, varied or distributed from a specific date in 2012. There was also provision which meant that if the defendants were going to be in a musical event, they had to give 48 hours notice to a particular police officer, and the particular police officer did have issues with our clients if they were going to perform. And these young men, 2 of them in particular, I think it's fair to say were pretty talented, and they were studying a music course at university, and they were producing music and were invited to perform in events, some quite mainstream events. There's statutory guidance as well that makes it clear that when these injunctions are made, there's particular points for good practice. They need to show very clearly the prohibitions and the requirements, and they must be clear and concise for the respondent and partners to understand. I mean, that really concerned me. I was looking at 4 pages of an injunction plus the further maps and exclusion zones, and I struggled to get to grips with exactly where they were with this. One of the defendants I was representing had special educational needs, and in his particular case it wasn't so much about the music, his strand of the case. I did refer to issues about capacity and the ability for him to understand what he was actually prohibited from doing, which was very onerous. The particular breaches in relation to the rap music that we faced were that these 2 defendants had congregated in a group of 3 or more people, that they'd taken part in a pre-organised music event without permission, and that they had acted in a way which would cause harassment, alarm or distress, and they had appeared in a distributed video material. It was all on YouTube, their music videos, which include threatening, abusive or insulting material, and it supported or incited gang-related violence and included reference to their gang. They did refer to their particular colour gang. I mean, it was a serious matter. I mean, there's an impact assessment from the Home Office that suggests that in approximately 59% of these committal proceedings, individuals are likely to get a custodial sentence in this civil matter regarding this breach. We really were on the back foot. We've heard a little bit today, and I really did experience this, that the police had officers who would spend a really long time trawling the internet for any kind of videos or posts from these two defendants. A substantial amount of evidence was produced showing various music videos, and at this point, you know, I did exactly what Khalid did, found my expert, Dr. Quinn, who produced a great report. I mean, I alluded to this briefly earlier, but I mean, her report was very clear that identity and prowess, violence and street values, illegal business dealings are all in there, but the fictional nature of the video, there's a big disclaimer, it may appear real. They say the props are fake and are used on media acting base only. So
it was an intertitle, wasn't it?
Yes,
on the screen saying it's a prop.
Yes, and it did depict, remember right, drugs, and I think there was a weapon as well. But they were saying this was props. I was thrilled with the report we got and the fact that I convinced the legal aid agency to fund this report. Sadly, the judge felt that he was qualified to make the relevant decisions about whether this material incited gang-related violence and what it was. He decided, and it's interesting because the Home Office guidance says that with these injunctions there are designated centres to deal with this, and this particular judge in a court in West London, which is not the area where my defendants were from and where the activity went on, so he wouldn't necessarily have that local knowledge. But it was decided that he was the expert and he did not need the expert evidence to assist the court. So I'm afraid we didn't get, despite all your good work, we did not get that report before the court, which was a shame. Now, the defence that we had to put. They were a family of musicians of Jamaican heritage. They took the music very seriously, as I've said. Two of them were studying music. I think, no expert on it, but I thought the videos were quite slick, quite good stuff. What we had to show, because there was no doubt they did refer to the particular gang affiliation and there were problems like this. So what my instructions were, and the defence that we were trying to put forward, was that even though the tweets, and the police had all this, suggested that they were made during the period of injunction, this was not the case, and I think this was another issue I asked Dr. Quinn to comment on in her report, about videos may be made much earlier with promoters then trying to look as though the music is just now being released. So we were very much looking at the timing of when this work was done. There was also a pre-organised music event that they didn't get permission for, and that was going to be a bit of a problem. But I mean, it really was a fairly mainstream event involving music from all different genres. I considered very much the Human Rights Act and Article 8, the right to respect for private and family life, because there was a lot going on. Like I say, there were nephews named in this injunction that they were limited the contact with. We really did come to the view that because it wasn't at the time of the injunction, it was very difficult for us to argue these points. Furthermore, looking at the legislation itself, the fact that the court does have powers to vary the injunction and that there's a review mechanism meant we didn't think we could bring a structural challenge under the Human Rights Act, either in respect of the right to respect for private and family life or freedom of expression. We talked earlier about prosecutorial discretion in the case of the criminal law. With the civil legislation and the gang injunctions and the statutory guidance, I at that time was looking at December 2011 guidance, but there's some updated guidance of June 2015 on gang bows, as they call them. It makes it clear that a local authority has to have regard to the guidance, and paragraph 11.3 of the earlier guidance, it's now updated in 2015, states that the application for a breach hearing is not mandatory upon breach of an injunction. So there is considerable scope for the local authority deciding when they note a breach whether there should be other things that can be done. What is the harm? They have to look at the seriousness of the breach, whether there have been any previous breaches, the progress that the respondent is making towards the positive requirements. If they're not getting involved in this alleged gang activity now, but actually they're leading pretty good lives, going to university, things like that. So I was saying, look, you should be looking at all this, and you haven't had regard to the guidance and trying to get it struck out on that basis. That there was a lot more discretion here in pursuing this, and they shouldn't have so automatically looked at breach proceedings. Because breach proceedings are serious. Whilst it is a civil matter and it's a civil contempt of court, it can be punishable by a maximum of 2 years in prison and an unlimited fine. So I had here defendants that just pursued their musical career. They posted some videos to advance their career. They could be going to prison for 2 years, not for a criminal offence, but because of this civil contempt of court and breach proceedings. How this case turned out in the end, it was really difficult. It was interesting because I haven't dealt in my work so much with the police in quite a few years, but we were on the back foot a lot. Obviously, I wanted to get evidence about when this music was produced, so I had to arrange to take witness statements from promotion people that were promoting their music and getting the witness statements in and people not turning up for appointments. And I finally get a witness statement, served. I think, yes, I've got it. I could show that this wasn't within, it's not a breach. And the day of a hearing, I would be faced with 300 pages of information from the police's computer, not about convictions of my witnesses, but my witness had been to a party when something disturbance happened and possible, very much kind of rumour-based intelligence. But for me to then deal with that with my witnesses, who are sometimes hard to pin down, just the lifestyle they were leading, and I'm sure a criminal solicitor probably gets this a lot more than, but it was hard. So we did have an uphill struggle. In the end, what really helped was we had the matter listed for a trial on 2 occasions, and particular police witnesses at the last minute had issues, I think medical issues, and we did make the most of that. We kicked up a bit of a fuss about the trial being put off and finally put sufficient pressure upon the local